Imagine, just for a second, pouring millions of dollars and thousands of hours into developing a truly groundbreaking piece of technology. You've got the smartest people in the room, you've done the work, you launch, and then you find out your patent is completely unenforceable. Why? Because you phrased a single claim incorrectly, or maybe because the legal landscape just completely shifted right beneath your feet while you were busy in the lab. It is literally the ultimate nightmare for any innovator. But the reality is, protecting cutting-edge technology right now is an immense challenge. You are essentially trying to build a fortress around an invisible, abstract idea, and the rules of construction are constantly changing. So today, we are taking a rigorous, systematic deep dive into the Supreme People's Court's 2025 Intellectual Property Court rules. We're going to decode the actual judicial benchmarks that will define how your technology is protected, defended, and enforced in one of the world's largest markets.
Hello and welcome. I am absolutely thrilled to be your host for this explainer. Okay, let's dive into this, because this is arguably the single most critical question facing chief technology officers and general counsels right now. How exactly do you protect tomorrow's technology? Things like decentralized consensus algorithms or mind-bendingly complex biotech compounds, using today's laws. Well, to answer that, we're going to take a highly structured approach. We are not just going to read through isolated legal jargon. That doesn't help anyone. Instead, we are going to follow what I call the life cycle of an innovation. We'll track a conceptual piece of intellectual property from the exact moment you try to patent its core technology, to how you defend its physical design, right through to how you aggressively enforce it against competitors out there in the real market.
To pull this off, we are leaning heavily on a foundational text, the Supreme People's Court Intellectual Property Court Adjudication Essentials Summary for 2025. Now, this is a massive, incredibly dense document. The court essentially sifted through thousands upon thousands of recent messy disputes, selected 132 absolutely pivotal cases, and distilled them down into 58 core rules. These aren't just theoretical, maybe this will work guidelines. No, these are battle-tested precedents. They represent the exact logic that judges will use to decide whether your company gets to keep its monopoly on an invention or if you lose it completely to the public domain. Our main goal today is to translate this really dense legal text into clear, actionable, strategic insights for your business. So, here is our strategic roadmap. First, we'll look at the 2025 IP landscape. Second, patenting cutting-edge tech. Third, defending designs. Fourth, enforcing patents in markets. And finally, we'll wrap up with our innovation strategy takeaways. Let's get right into it.
Section 1. The 2025 IP Landscape.
Right. Before we zero in on specific niche technologies, we really need to understand the sheer massive breadth of the judicial guidelines we're dealing with here. The scope of the 2025 SPC Adjudication Essentials is breathtakingly comprehensive. It literally covers everything from the initial authorization and validity of a patent right through to really heated disputes over ownership and infringement. But it goes way farther than that. It governs things like new plant varieties for the agricultural tech sector, those intense high-stakes battles over trade secrets, complex anti-monopoly disputes, and even crucial procedural matters like exactly how evidence needs to be handled in court. The big strategic takeaway here is simple. Whether your company is writing thousands of lines of blockchain code, engineering new drought-resistant agricultural seeds, or mixing complex pharmaceutical chemicals, these rulings are going to impact your overarching business strategy. The court has essentially created a unified philosophy across every single field of innovation.
Section 2. Patenting cutting-edge tech.
Okay, now let's shift our focus to the very beginning of the innovation lifecycle, the creation phase. How do you actually secure a patent for emerging, highly abstract technologies? This brings us to one of the most rigorously debated topics in all of global IP right now, patenting software and blockchain. It's a minefield. On one hand, we have a pure data structure. Now, in the eyes of the court, this is just math, plain and simple. It's an abstract intellectual rule, and because of that, it is entirely unpatentable. You simply cannot own a mathematical concept. But on the other hand, we have an applied consensus algorithm solving a technical problem. And now this is patentable. The line between these two concepts, that is exactly where millions of dollars of enterprise value are either created or completely destroyed. So the million-dollar question is, how exactly does the court tell the difference?
Now, what's really interesting about this slide is how Rule 1 provides a crystal clear answer to this dilemma. This rule stems from a huge landmark case involving a fault-tolerant blockchain consensus method. The court basically stepped in and stated explicitly, yes, a blockchain at its very core is just a data structure. We get that. However, if your patent claims restrict that algorithm to a specific application scenario, and if it integrates things like distributed networks and cryptography to form a comprehensive solution that solves a real-world technical problem and achieves a tangible technical effect, well, then it crosses the line. It goes from being abstract math into protectable technology. You aren't patenting the math itself. You are patenting the mechanical, real-world execution of that math to fix a tangible problem. This is the exact, precise phrasing your engineering and legal teams need to be using when they are drafting software claims.
Let's pivot for a second from the digital world over to the biological one, because honestly, it faces a very similar hurdle. In biotech and pharmaceuticals, innovators often don't invent entirely new elements out of thin air, right? They usually find new life-saving uses for existing, already known compounds. So how do you prove that is actually inventive? Well, the court formalized a really rigorous 3-step method in Rule 20. Step 1, you have to acknowledge that there are numerous known compounds already out there in the existing public domain. Step 2, you show that you intentionally selected a very specific compound as your research starting point. And step 3, and pay attention because this is the absolute most critical step, you must prove the uncertainty in the technical prompt. You have to demonstrably show that a person skilled in this specific field would not have naturally or easily thought to use this compound for this brand new purpose.
This whole principle was totally solidified in the CETP inhibitor patent case. And the strategic takeaway for biotech innovators here is just profound. Uncertainty is literally your strongest weapon. Think about it. When you are sitting in the lab documenting failures, documenting dead ends, and meticulously documenting why a specific chemical reaction was highly unpredictable, you aren't just doing science. You are actively building your legal defense. If a competitor later comes along and tries to invalidate your hard-earned patent by saying, oh, your invention was obvious, your lab notes, the ones proving the deep uncertainty and the immense risk you took to get there, will be the exact thing that saves your IP.
Section 3, Defending Designs. Let's move a bit further down the innovation lifecycle. Once you have your core underlying technology patented, you usually wrap it in a product design. But how does the court view the visual and functional boundaries of physical products? We actually find a great answer to this in Rule 28, which deals with the security wall design patent case. You see, very often, companies try to patent a design in a vacuum. They picture it as a standalone object, just floating in white space. But the real world is messy, right? Products are installed in very specific, contextual environments. In this case, the court had to decide if a design was actually novel, and to do that, they looked heavily at the physical environment where the security wall was meant to be used. They determined that the environment itself dictates the level of protection. So, the crucial point is that the usage environment severely limits your product's design protection. Let's say you invent a product that is specifically designed to be hidden deep inside an engine, or maybe it's installed in a highly restricted security environment where the general public literally never sees it. That context matters deeply to the court. You cannot turn around and claim that a competitor infringed on your visual design if their product is used in a completely different, public-facing environment, or if the secret nature of your installation meant the design wasn't truly acting as a public visual identifier in the first place. The overarching strategy here is precision. When you file a design patent, you must explicitly define its use case and its environment. Don't overreach, or I guarantee your patent might just collapse under its own weight. Section 4. Enforcing patents in markets. All right, now we reach the most aggressive, high-stakes phase of the life cycle. You have your tech patent, you have your design patent, and you are finally out there in the market. How do you actually stop competitors from exploiting clever loopholes, and how do you navigate the safe harbors that the court provides? Well, in the tech hardware space, there has historically been this massive loophole known as divided infringement. Imagine this. You hold a patent for a brilliant smart device that requires both a specific piece of hardware and a specific software app to work together. A competitor comes along and they only sell the hardware. They throw their hands up and say, hey, we aren't infringing. The consumer is the one who downloads the software and puts them together. Go sue the consumer. Well, Rule 41 shuts this loophole down completely. It formally defines infringement by manufacturer. If you knowingly manufacture and provide hardware that is clearly, undeniably meant to be combined with specific software by the end user to execute a patented method, your act of selling that hardware constitutes patent exploitation. Full stop. This was completely cemented in the thermal imaging device case. In that situation, the competitor tried to sell just the thermal imaging hardware, basically leaving the software integration entirely up to the buyer.
the court saw right through this trick. They ruled that because the manufacturer knew full well that the hardware was practically useless without the software combination that infringed the patent, the manufacturer themselves was liable. For anyone out there building IoT devices, smart home tech, or modular hardware, this is a massive, game-changing victory. It means you can go straight after the root cause of the infringement, the rival manufacturer, rather than trying to chase down thousands of individual end users, which is practically impossible anyway.
However, it's important to remember that the court doesn't just blindly hand out absolute monopolies. It also wants to protect the broader ecosystem of continuous innovation. And this brings us to Rule 53, the scientific research exception. The rule states, patents used solely for scientific research and experimentation do not constitute infringement. Think of this as a legal sandbox. The court fundamentally recognizes that for science to actually progress, competitors and universities need to be able to take your patented device apart, reverse engineer it, and push its limits just to figure out how to invent the next generation of technology. And this brilliantly illustrates the boundaries of that legal sandbox because, make no mistake, this sandbox is heavily fortified. The commercial limits of Rule 53 are incredibly strict. You can play, but you absolutely cannot sell. The use must be purely for scientific research. There can be absolutely zero direct commercial intent. If a competitor is reverse engineering your product just to immediately build a cheaper knockoff so they can sell it next quarter, that is absolutely not covered by this exception. Furthermore, the court subjectively looks at the entity doing the research. Are they a legitimate scientific experimental entity or just some shell company trying to sabotage your market share under the guise of research? The court is actually quite good at spotting corporate espionage dressed up in a lab coat. This rule is designed to protect true R&D while ruthlessly punishing bad actors who are just masquerading as science.
Section 5 Innovation Strategy Takeaways. Well, we have traversed the entire life cycle of innovation through the lens of the Supreme People's Court. We've gone all the way from abstract algorithms to aggressive market enforcement. Now, let's translate these dense legal precedents into a concise, actionable business playbook. If you are leading an innovation-driven enterprise right now, here are the strategic actions you must implement for 2025 based on these specific rules. First, audit your software and blockchain patent claims immediately. You need to ensure they are framed entirely around solving real-world technical problems, not just protecting clever math or code. Second, train your biotech and hardware R&D teams to meticulously document uncertainty and failures in their lab notes. Remember, this is the absolute bedrock of proving inventiveness. Third, when you're filing design patents, explicitly restrict them by their intended use case and physical environment to ensure they actually hold up in court. And finally, monitor your market not just for direct, obvious clones, but for competitors selling software-ready hardware designed to piggyback off your hard-earned ecosystem. Because under the new rules, you can finally shut them down.
Look, innovation waits for no one, and clearly, neither does the law. The rules of the game have been significantly updated, clarified, and sharpened for the modern technological era. The strategies that might have perfectly protected your company 5 years ago could leave you entirely exposed today. So I want to leave you with this final, critical thought to take back and discuss with your teams. Are your current patents written merely to describe the technologies of yesterday, or are they rigorously engineered to withstand the legal standards of 2025? Thank you so much for joining me on this explainer into the 2025 IP landscape. I hope you found it as fascinating as I did.